All right, let's break down some of the testimony from yesterday. I'm back here with criminal defense attorney Rachel Kugel. Rachel, the defense did an interesting job, the prosecution did an interesting job under cross-examination. I'm curious your perspective on what you saw before.
Yeah, I mean, I think it's sort of what we were talking about before, right? His actions belie the point. There was planning, there was, and also it goes to this point of making him scary for the jury. That is emotionally important here, right? Because the defense is trying to make him sort of a sympathetic character, that he was talked into it, that he, has developmental delays and issues. The prosecution's point is, look, this guy planned this thing. There was significant planning, and when the murder actually took place, it was all him as far as what he decided to do. And quite frankly, it was scary, right? Because as our forensic expert today pointed out, stabbing somebody is a very difficult thing to do, right? There's no distance between the two. It's a very sort of passionate, emotionally involved thing. It is not easy for somebody to do something like that. And so that also points to that fact of making the jury a little bit scared about this guy. And it's an undercurrent here that I think is important.
And especially that he wanted to rape her and slit her throat in such a violent manner. I'm back here again with Joseph Scott Morgan. Joseph, I want to ask you a quick question. Munchausen syndrome by proxy, they believe that Dee Dee suffered from that. When you're listening to the testimony of Gypsy Blanchard, the idea of what abuse she suffered, does it seem clear to you?
Yeah. My God, the things she endured. One thing that always comes back up in my mind is reading the initial reports of how this young girl was fed Roundup weed killer, and it causes this toxicity in her system that would mask things. I mean, that would present essentially clinically as like an MS. It caused her teeth to fall out. All of these things, and I'm thinking, to what point do you go for gain at the expense of your child? And that's, oh boy, this is one of the more darker things I've covered over the years.
And Joseph, I'm going to say the same thing. It really is, and we've both seen a lot, so it's saying something. I don't think I've seen a trial quite like this. Hey, listen, we have a live feed into Go to John. Nothing's happening quite yet. When we come back, we'll show it and we'll talk more about it. We'll be right back. Stay tuned here on Law and Crime. Okay, let's break this down right now. I have two special guests. First, I want to bring on forensic death investigator from Jacksonville State University, Joseph Scott Morgan. Joseph, this is the prosecution's rebuttal witness to talk about a very sensitive topic in terms of autism. What are you looking to see here?
Well,
excuse me.
Clarity. As you can tell, this testimony is weighed down with a lot of numerical data, and I want to know. I want to know what this guy knows about autism. And one of the things that kind of struck me just a moment ago, when you're an expert witness, you kind of want to talk about your background and how much experience you have in the field. He does have experience as a forensic psychologist, but did you note the number of cases that he said that he had experience with relative to autism? There really weren't a lot. As a matter of fact, counsel went back and said, so you're three, I think he said 3, 4, 5. He said, so Mr. Godejohn is one of those. And that kind of, plants that thought in the minds of the jury, like, this guy really doesn't have a lot of experience as it applies to autism examinations. So that was kind of compelling for me.
That's a great point that you made, and I want to ask a different question now for my other guest, criminal defense attorney Rachel Kugel. What we know that Denny said, he was said to answer the court's question, did Godejohn premeditate Dee Dee's murder? A psychologist has to review evidence like the text or Facebook messages, and he's quoted as saying, you'll get maybe what they told you. You can't, as a psychologist, spend a lot of psychological theory trying to explain that, but if you don't look at this stuff, you're not going to understand what was really going on at the time. What do you think? Yeah,
I mean, I think what this comes down to, and I think, again, why it's a problem, remember, capacity, that issue's been decided. So anything about whether he has, the ability to stand trial or understand the nature of what's going on before him, we're past that point. So now we're at the point of, did he know right from wrong? Does he meet the legal standard of diminished capacity? That's where texts and things like that come in. What was going on in his mind the day of? This goes also to, it's not objective, it's subjective. What did he think at that time? And I think this is a real problem for them, because ultimately we're not talking capacity, we're talking shocking legal standard, and his actions belay the argument. I think this might go to, mitigation in terms of sentence. And remember, in this state, I believe the jury does get to actually decide or have input on the sentence that he gets if they find him guilty. So it may go to mitigation in terms of sentence, but I'm not sure it gets him to not guilty.
That's one of the other unique aspects of this case. It's not a death penalty case, but they will be able to determine the sentence if they find him guilty. Let's go to a quick break. When we come back, we'll be live in the courtroom. Okay, I want to see if we can break this down right now with Joseph Scott Morgan. This is an interesting witness talking about the spectrum and, the level. There's a level 1 and placing him at the highest functioning level. I'm curious what you're getting from this line of testimony, both under cross-examination and now under redirect.
Yeah, what I'm getting from it, Jesse, is this, you have to contextualize what he is saying relative to the events that occurred. He's talking about, attachment to motor skill and response and response times and all these sorts of things. I don't really see how the jury is going to see how this plays into the decision-making process. Let's keep in mind, this event was not done acutely. It wasn't done. This homicide was not perpetrated in an acute moment in time. It was planned over a period of time. So I'm having a real hard time, and granted, psychology is not necessarily my forte, but I do know enough to understand that if you have enough time to plan this thing, and they did, how is his ability to make short-term decisions impacting his ability to make long-term planning? I don't really understand that. I think that has to be explained very carefully to the jury, to let this guy make hay with all of this.
Well, I'll tell you what, we're going to bring on Rachel Kugel a little bit later because we just want to jump back into court, but she'll help explain for all of us about how this ties into what the jury should be thinking. Let's go back live into court.
Yes, sir.
Is that true?
Yes, sir.
That's all I have, Judge.
Thank you. Will Dr. Denny be excused?
Yes, sir.
Doctor?
Thank you, Your Honor.
Thank you. Folks, we have some students in the courtroom today. I want to remind you that the rules apply to everyone, that you won't be able to use your cell phones while you're in the courtroom, okay? All right. So, Mr. Patterson, do you have any additional rebuttal evidence?
Your Honor, that concludes the rebuttal evidence.
All right. Mr. Perry, do you have any serve rebuttal?
We do not, Judge.
All right. Ladies and gentlemen, we've reached the point in the trial where all of the evidence has been presented. Both parties are rested. I have to work with the state and with the defense in crafting some jury instructions for you. If I could see the parties over here, real quick.
Well, the timing of this couldn't be better because now we can break this down from a legal perspective. Rachel Kugel's back with us. So what is the jury gaining from that rebuttal witness? Very interesting strategic move for the prosecution to do that, but what did they gain from this testimony?
I mean, I think that the prosecution didn't want to leave the defense expert sort of hanging, right? I mean, I think they wanted to kind of tie up that loose end by putting on their own expert. In all honesty, I don't think that this testimony was so incredibly compelling. I mean, all it really did was sort of try to sort of take apart the defense expert and say, look, he's got problems, but they're not sort of big enough to justify a diminished capacity defense, right? He's on the spectrum. He might have some problems with cognitive things, but it doesn't, rise to the level of meeting their requirements, the defense's requirements, to show a diminished capacity defense. And, I don't think other than that it really laid a whole lot out for us. For me, looking at this whole thing, I really feel like the defense would have done better by putting up family members or someone that could have humanized him rather than these experts. I mean, obviously the expert's necessary, but it just seems to me it's leaving a big chunk on the table as to what this guy functioned like in his real life. I would have liked to hear from his mother or his father about how he functioned and how he actually existed in the world. I think that might have helped more, and it also might have humanized him because, as I've pointed to a few times, without a psychological defense to this, this is a super scary crime. And I would be worried as a defense attorney that jurors have that emotional fear as they're making their decisions. And while all of these things might go to some mitigation in sentencing, I have not heard a valid defense.
Well, we're going to have to see. You make some really good points there, and it's not an easy job for the jury in this case. Let's take a quick break. We'll be right back. Wow, this is fascinating. Rachel, a lot to take in from this testimony. What are you really pinpointing here? I mean, there's a lot to the role playing, the planning.
Yeah.
What do you think?
Couple of points. First, with regard to the role playing, you know, in the role play, he's the master, she's the slave. I think that's a problem if you're trying to argue that he was somehow manipulated by her. If he's in the master role, that doesn't really fit that narrative. So that's one problem I have with it. The other is when we're talking about role playing, we're not talking that he didn't understand the difference between reality and fantasy, because we're past that point, as I've said a few times. He has already been found fit to stand trial. So we're past the point. He knows reality versus fantasy. Now we're talking about, did he understand right from wrong? Could he plan? And while role-playing, you know, might be sort of engaging in fantasy behavior, it's not enough to meet that diminished capacity defense. The other point I notice is she mentions they wanted to do Plan C, which was, I think, to get her pregnant, but his mother wouldn't allow it. Well, this points back to what I was saying before, that I would have liked to hear from that mother, because if, as a grown 20-something-year-old person, he still has to talk to his mother about who he can have relations with and dates with, well, now I'm interested in what was wrong with him and what kind of mental capacity he actually had. If at that age he was still, most guys at 20-something are not talking to their mom about who they can, you know, hook up with, quite frankly. So it just points to the fact that I would have liked to hear that kind of testimony in this case, and it's missing.
Hey, listen, their history is what this whole case is about, but it's also about what did we find at the crime scene and what was the timeline of events. So I'm back here also with Joseph Scott Morgan. Joseph, we saw some interesting things in court previously. What was found, you know, Gypsy's bag, we found these handcuffs, we found all this money, we saw a shoe that had blood on it, and you made a really good point about the bloody shoe. Can you talk about with our viewers what you noticed about that?
Yeah, right off straight away when I saw the blood, you know, on the shoe and just passing, we were just discussing it. It looked as though to me that the shoe had actually, or one of the shoes, I can't remember which one, had actually been present, and when blood was freely dropping through the air, and it's a kind of a low velocity impact onto the surface of the shoe, which gives us the impression of the dynamic of the environment in which they were indwelling. Say, for instance, you know, if they're trying to clean up the scene, blood is free flowing and dripping off of, say, a blood-soaked sheet, drops onto the top of the shoe, and it gives you an idea. Also, one of the things I'd be curious about is to see if the shoe had been you know, used to traverse through a puddle of blood, and to see what was going on with that. Was there any other indication on the clothing of blood that was left behind? To, you know, because again, we weren't there. We don't know actually what happened. That's the beauty of forensics, because we can go back and kind of tell a story about these events.
Yeah, that's what I love having you on. We take these physical pieces of evidence and it's telling a different story. I have a question, though, for Rachel, and I've asked some guests this. She didn't go to trial, right? She pled guilty. If she did go to trial and she presented this, I am the victim of my mother who suffered from Munchausen syndrome by proxy, have you ever seen that as a defense? And if not, do you think it could have worked here?
So, I mean, I think it has been tried, and I think in this case it could have maybe worked. Although, let me say, I actually think that her plea deal was not only good for her, but actually just. I mean, I think that her side of the case came out right. And I think she actually probably will get paroled and all of that at her next hearing. So I think her case turned out right. She definitely had a shot at a defense, but again, was she going to get less than 10 years? I mean, I think she got a very good deal and a good outcome. I think it was the right move of her attorneys to recommend it and for her to take it. But she is the one that had the defense here. And they're trying to sort of, by association or by osmosis, impart her defense to him. And that's where I think they lose something, because he doesn't really have his own defense, right? His defense sort of is by osmosis of hers. And that's
what makes this a unique case, and I've never seen anything like it. Rachel Kugel, Joseph Scott Morgan, it was great having you both here. I can't wait to have you both back. Maybe we'll analyze the ultimate verdict in this case when it comes down. So thank you, both of you. Have great weekends, and thanks for coming on.
Thanks for having me.
All right,
Thanks.
everybody, let's take a quick break. When we come back, we're going to talk more about the Nicholas Godejohn case. And as you hear, there's so much to talk about. We'll be right back.